just days after handing President Trump two major legal victories on immigration. The Supreme Court has issued a new series of split decisions for the administration. The justices expanded executive power that would allow the president to fire one federal employee, but rejected his bid to fire another. In a decision that could impact the midterms, the justices ruled in favor of a Mississippi law that allows elections officials to accept mail-in ballots that arrive after Election Day so long as they were postmarked by Election Day. And then the justices also ruled that constitutional privacy protections must extend to cell phone location information. And the court refused to hear the president's bid to overturn his conviction for sexually abusing and then later defaming writer E. Jean Carroll. Let's dig a little deeper into all of this. First, the Supreme Court clearing the way for President Trump to fire the heads of most independent federal agencies at will. In a 6-3 decision, the justices ruled Trump can fire Rebecca Slaughter from the Federal Trade Commission. That overturns a unanimous decision from the court in 1935 that protected the independence of government agencies. The ruling effectively makes FTC commissioners and those who staff independent federal agencies serve at the president's discretion and eliminates Congress's bipartisan requirement for the agency. In a concurring opinion, Justice Neil Gorsuch wrote, quote, "Independent agencies are not so independent after all." Justice Sonia Sotomayor, who defiantly read her dissent from the bench, fired back, writing in part, quote, "This court undoes centuries of political practice and concludes that all three branches of government have been acting in open defiance of the Constitution all this time." But the court's making an exception for independence when it comes to the Federal Reserve, at least for now in this instance. In a separate 5-4 decision, the court ruled Federal Reserve Governor Lisa Cook can keep her job as she fights bogus mortgage fraud claims from Trump and his allies. Despite that, Trump celebrated the ruling on social media and said the administration would, quote, "take appropriate action immediately to remove Cook." And then when it comes to mail-in ballots, which of course will impact the midterms, as we mentioned, the Supreme Court yesterday upheld a Mississippi law that allows ballots to be received up to 5 days after Election Day. It's a major loss for President Trump, who has repeatedly pushed unfounded claims of voter fraud, even as he himself chooses to vote by mail frequently. The Supreme Court's decision emphasized the Constitution gives election authority to state legislatures and Congress, not the president. Trump was quick to criticize this one. In a social media post, he said it's now more important than ever for Congress to pass his controversial elections bill, what he calls the Save America Act, that would require proof of citizenship and photo ID to vote. Let's start there with MS Now legal affairs reporter Fallon Gallagher. We might be your favorite show because we let you do this in the AC as opposed to sweating it out outside the Supreme Court. You're going to head back there later because today is going to be a big day. But before we look ahead, let's unpack what we've got, because especially when it comes to the way a president can and cannot fire people at independent agencies, we were putting those together in a bucket, but the decisions sort of split a hair. And I wonder what you make of the way that they're doing that.
Yeah, and that was honestly not very surprising to me because the justices signaled that from the very offset when they decided to take up these cases. You'll remember that both of them came through the emergency docket, but they approached them differently. They said that Rebecca Slaughter could stay fired while the court decided the case, but Lisa Cook could stay in her job. And that's kind of always how they were signaling that they were going to go. Now, with the Slaughter case, I cannot underscore enough how much this will fundamentally reshape executive power. Yeah. Of course, we talk a lot about the birthright citizenship case as the landmark case of this term. This is also a landmark case, and the court is overturning a 91-year-old precedent. The court does not do this lightly, and this is really, really significant. So basically what this is going to do is this removes any statutory protections for these independent agency heads. So previously, presidents could only fire these people for cause, meaning if there was malfeasance or neglect of duty. Now he can fire them at will. Those protections are gone because the court is saying that's a separation of powers issue. The executive should have that authority, not Congress. Now, on the other hand, Lisa Cook, it's a win for Cook. It's a loss for Trump, but on narrow grounds and only for now. So what had happened there is that the lower court blocked Cook's firing in a very preliminary way. That case is fresh. Like, if I remember back in arguments, Alito had asked, are the mortgage records in question? Because, of course, the president had accused her of mortgage fraud. Yeah. Are they even in the case record? Like, that's how early this case was. So what they're doing here is they're saying, we are denying your request for a stay of that decision for now. We're sending it back for further litigation. But they're sending really strong signals that they view the Fed differently. So a win for now, a major win for President Trump on the Slaughter case, because that is just going to fundamentally reshape the executive.
And what you've heard people who are critics of that decision say is, okay, so you're saying that the Fed is so important an agency that it should be independent and not subject to political whims, but all of these other independent agencies that are equally important in different ways can be. And I think that is something that will have clear ripple effects. I think you're also right. It takes a lot to overturn precedent, and they don't do it lightly. But this court is certainly entertaining doing it pretty frequently, especially when you consider just a few years ago overturning the Roe versus Wade precedent that had 49 years at that point of being existing precedent. But then, of course, we're looking at, too, the ways that they contend with these active issues that will impact the midterm elections. Of course, you had the Mississippi decision there on mail-in voting. Then you've got another elections decision coming today on basically the way that money can flow through elections. So talk about what we saw and what we might see then when you kind of put these in the elections-related buckets.
Yeah, and yesterday's ruling was a bit of a surprise from this conservative-leaning court. During arguments, it seemed like they were likely to possibly overturn these laws, which would have had implications in 18 states and territories for the midterm elections. Basically, the court was weighing whether or not Election Day meant the actual Election Day, or if these grace periods that these states have, the law in question is a Mississippi law, which has a 5-day grace period, but they ranged. I think Texas is on there. I think they only have a 1-day. But as long as your ballot is postmarked by Election Day, it can be received. Now, this was a Barrett opinion. It's a 5-4 opinion. And the court is saying these laws actually hold. There's nothing in federal election statute that says that the election day has to be the election day. And so this was, the president's really upset about this, but this was also sort of narrow when all things are considered, because during arguments, they had raised the question about whether or not this could impact early voting. Of course, millions of Americans vote early every single year. And so for now, they're saying these laws can hold and that people can continue to have these grace periods, which will have major implications as we get closer to the election, because if this had overturned, people would have had to cast their ballots much earlier to make sure that they got there on time.
Also, the idea, too, for the president, he's upset about the ruling, and this adds only more fuel to an already raging fire on Capitol Hill of trying to pass this voter ID bill that has all sorts of negative implications for people as they try to register to vote. Republicans don't have the votes on it, and yet the president is just sort of blowing up all these other legislative priorities, including the housing bill, to try to get this voter ID bill passed. We'll keep tracking that, but I think the court ruling is, more fuel for that. And then, of course, instructive. We're going to talk to a lawmaker in a state that is universal vote by mail about the impact of that ruling. But then there was also this, because the president has been active on social media, this time expressing surprise after the Supreme Court declined to review his appeal in a civil case involving writer E. Jean Carroll. In 2023, a federal jury in New York decided in favor of Carroll, who said Trump had sexually abused her in the mid-1990s in a dressing room of a New York City department store. And then he later defamed her. The jury awarded Carroll $5 million in damages. Yesterday, the Supreme Court declined to review Trump's appeal of that case. In response, Trump blasted the high court on social media, writing in part, quote, "Surprisingly, the Supreme Court declined to review a fake case brought against me by a woman I never met." Carroll released a statement that read in part, quote, "His multiple efforts to appeal that verdict have all failed, and today's ruling ends his quest to avoid accountability for his actions." Trump's attorneys say they also plan to appeal another $83 million verdict awarded to Carroll by a different jury after a second defamation trial. But still, notable that this is where the court would land on this. And, of course, the president's reaction saying he's surprised is unsurprising.
Yes, this is the end of the road for this, for Trump's appeals on Carroll, and so he will have to pay this defamation verdict. This was not entirely a surprise from the Supreme Court, though. Of course, they deny most cases that come to them, but this is a case, so before the justices take up a case, they have to conference it, meaning they all have to sit together and decide whether or not it's something they want to take up. This case, for many, many weeks, was on the conference schedule, canceled, rescheduled. On the conference schedule, canceled, rescheduled. And so some people were worried about, oh my gosh, what is this going to mean about when they take it up? To me, that read, they don't want to touch this. And they don't. They came on the orders list yesterday. Typical, we get orders Monday mornings usually. Usually it's just a long list. Sometimes there's an explanation, but usually there's not. This did not have an explanation. They do not want to touch this case.
And so now we see that they won't, at least in this one singular instance. And then there's the cases that we know they're going to touch and that they're going to decide today, because today is the last day of the court term. What are you looking for? There's 4 cases outstanding that we really care about.
And that's what's so funny about the last day of the term. It is the only decision day where I actually know which cases we're going to get. It's just a matter of which order do they come. So, of course, we know birthright citizenship. We've been guessing that this would be on the last day. They usually like to drop the biggest case and then get out of town. I would not be surprised if that's a Roberts opinion, which would mean that we would probably get it last today. But there are two other important cases. You talked about the campaign finance case. That will fundamentally change the way that political parties can work with their candidates. Yep. And if they decide the way it seems like they might decide and transition this power, this will move spending power and collaboration power from super PACs back to the major political party groups, the RNC, the DNC, the NRSC. Interesting, this was a case that was actually brought by J.D. Vance when he was running for Senate back in 2022. But this will change the campaign finance landscape, especially in this midterm year. The other case is it's actually a pair of two cases involving transgender athletes, two transgender women who wanted to play, actually both on the cross-country and track teams. And the state's laws, there's laws like this in 27 states across the country that ban transgender women from playing on the women and girls teams. The court seems poised to uphold that ruling and allow those state laws to stay in effect. If that happens, it wouldn't be likely would not be a nationwide blanket ban on transgender women playing in girls and women's sports, but it would allow those 27 state laws to hold. And that's what it seems like they're going to do. The only thing that makes me a little bit concerned about that is that this case was argued all the way back in January, and it seemed pretty clear cut. So, of course, we'll have to wait to see today what they do. But those are our last four cases, and then the justices are going to get out of town.
Yeah, you're sort of forced to question, okay, if you leave the thorniest rulings to the end of term and the last day, why are the trans athlete cases part of that? I guess we're going to find out in the next few hours. We will, of course, be watching you on Morning Joe. And then, of course, outside the court, MS Now legal affairs reporter Fallon Gallagher. Get some coffee. Thank you.